Hi, everyone. I'm so honored to be here. The organizers of this esteemed conference asked me to come by to talk, to make the case that what we're talking about today, labor and employment law and poverty law, are deeply intertwined and closely connected. So I want to talk a little bit about the concrete stakes of labor and employment law today. Over the course of American history, the single greatest intervention that has effectively limited income inequality and ensured shared prosperity is increasing union density. The Congressional Budget Office, The Congressional Budget Office estimates that a nationwide $15 minimum wage would move about 1.3 million people out of poverty. Over the course of a year, hard data shows that the vast majority of people on SNAP benefits work. In 2018, 5.7 million Medicaid enrollees worked full-time for the full year, but earned wages so low that they qualified for these federal benefits. Many SNAP recipients work full-time for America's most wealthiest and most profitable companies, but their pay is so low that their household income is, in fact, at the poverty line. This is true even though last year, Walmart's gross profits were over $143 billion. Other SNAP recipients don't work full-time over the course of a year because their employers intentionally keep workers in easy-to-exploit part-time roles where they are paid even less than their full-time counterparts, or because they work in volatile, high-turnover industries with low pay, grueling hours, and no job security where they can be fired at will. And during the pandemic, the government response to the pandemic kept a staggering 53 million people above the poverty line across 2020 and 2021, cutting the child poverty rate in half and dramatically reducing the poverty rate overall. I look at these pieces of data, which might seem like they're about different things, and I use them to remind myself that poverty is a policy choice. It is a policy choice shaped by, reflected in, and entrenched by labor and employment law and policy. Poverty is a policy choice made by a legal system that makes it far too easy for employers to legally underpay their workers, and then makes it far too easy, as some of the folks who were on the last panel explained, to routinely evade accountability for employers when they do break the law. Poverty is a policy choice made by a system that for generations has disempowered workers, our families, and our communities in favor of the corporate bottom line. But it's also the law and policy of how workers build power, exercise collective agency, and take back economic security. So I want to start with a few concrete examples of the ways that labor and employment law leaves people in desperate financial circumstances. So as this data shows, and as many folks here are familiar with, wage theft is rampant across the American economy. I want to give an example of the kinds of workers who are most vulnerable to it. About a month after Hurricane Harvey, Carla Lopez responded to a Facebook post looking for workers to repair flooded buildings in North Houston. She was offered $11 an hour to work extremely long days, 6 days a week with no overtime, already illegal. About 3 weeks into the job, Lopez was injured, but her employer not only stuck her with her medical bill, they refused to pay her for the weeks she had already worked. It turned out that some of her coworkers had been waiting to be paid for more than a month. In the first month after Hurricane Harvey, more than a quarter of recovery laborers, many of whom were Central American immigrants, reported that their employers stole their wages. And then those workers reported, and enforcement lawsuits have later confirmed, that those recovery contractors not only stole hundreds of thousands of dollars from the workers making our communities safe after fires, floods, and hurricanes, they then threatened those workers with losing their jobs, with being reported to ICE, or even with physical violence when they asked for their most basic minimum wage rights to be respected. Lopez and her coworkers went to a wage theft clinic run by the Workers' Defense Project, who got them their money back. But it turns out that, they're not alone, right? Immigrants, workers of color, the most vulnerable workers, the people who are subject to all of the forms of exploitation that intersecting forms of exploitation routinely experience wage theft on the job. And as Graham spoke about on the last panel, many of those workers are unable to effectively vindicate their rights because they're subject to forced arbitration clauses. Today, more than half of non-union private sector workers have a forced arbitration clause snuck into their employment contract that legally bars them from going to court when their rights are violated. And that means that instead of going to court, being part of a class action, workers' only way to vindicate their rights is to file a arbitration in a shadowy proceeding, which will then be judged by an arbitrator handpicked by their employer and paid by their employer, often to the tune of, this is true, $1,000 to $2,000 a day. So it is no surprise that workers are less likely to win in arbitration. They are less likely to receive significant damages when they do win. And the reality is that the vast majority of workers who would have filed claims in class actions simply don't file claims in arbitration at all. So arbitration effectively functions as a way to deny workers their rights under minimum wage law. Here's another example. Take unemployment insurance. Unemployment insurance is one of the safety net programs that keeps Americans out of poverty. During the COVID-19 pandemic, from mid-March to mid-June, more than 44 million Americans filed for unemployment insurance at a time that unemployment was spiked to the highest rate since the Great Depression. At the height of a pandemic that was killing Black and Latinx workers at twice the rate it was killing white workers and killing Indigenous people at elevated rates, workers of color were more likely to be losing their jobs, had less likely to fall back on because of a deep racial wealth gap, and they were more likely to work in the retail, food service, and shipping jobs where they would be at elevated risk of COVID-19. So for those workers, unemployment insurance was a lifeline. And yet during the pandemic, as we talked about, during this moment of profound economic calamity, poverty fell rather than increasing because of twin changes to fiscal policy and employment law. A major driver of poverty falling in 2020 was the COVID-19 pandemic UI package. Congress's third COVID-19 relief package, the CARES Act, provided urgently needed relief to workers who are losing their jobs en masse by expanding UI coverage and providing an extra $600 a week in benefits to every person receiving benefits. But the Act's benefits were temporary. The GOP-controlled Senate refused to reauthorize the program, and when it expired on July 31st, 2020, tens of millions of workers were returned to state unemployment insurance programs, which at the time paid workers an average of just $320 a week and pays many workers far less. I don't know about you, but I can't make rent on that, and neither can many other people. But unfortunately, this is the reality for many people on unemployment insurance. The UI program is a critical safety net program, but it's a profoundly broken one. Millions of workers are excluded from the program entirely. So this chart on the screen right now shows how many unemployed workers in the third quarter of 2022, now that pandemic era expansions to UI have expired, qualify for unemployment benefits. And as you can see, in the vast majority of states in the country, less than 20% of people who are unemployed are able to access those benefits. That's for a variety of reasons, many of which reflect the workers who are left out of employment law's protections in general. For example, millions of workers are misclassified as independent contractors nationwide. Those misclassified workers are ineligible for unemployment insurance, despite the fact that many of them are working some of the most precarious and low-paid jobs in the country. The CARES Act also had a program called Pandemic Unemployment Assistance, a program that temporarily addressed this exclusion during the pandemic by extending emergency UI to independent contractors, misclassified workers, and freelancers. But when that program expired at the end of 2020, those workers were left out of luck. And if they lose their jobs now, or they can't work for other reasons, for example, because they suffer a disabling illness or an injury, they are simply ineligible for UI. Other workers are excluded from UI because of profoundly punitive work history rules that vary significantly from state to state, but generally say that workers only qualify for UI if they have worked for 4 of the last 5 calendar quarters. So many workers, especially workers with disabilities, workers who are returning to the workforce after incarceration, caregivers, workers who have loose attachments to full-time work for all kinds of reasons, simply don't work sufficiently during that period to qualify for benefits. Or even like a student graduating from law school and starting to work and then starting to work who like loses their job 3 months in because of something totally out of their control, typically in many states does not qualify for UI benefits. Anyone who works insufficiently during the base period, typically excluded. Pre-pandemic, many low-wage workers were ineligible for unemployment insurance because they did not earn enough wages in their low-paid part-time jobs to qualify, even though those workers were the most likely to need them. In part because of strict work history requirements in the last quarter of 2019, just 9.5% of unemployed workers in Mississippi received unemployment insurance. Now, this may sound very dry, but for what I think it is connected to, what this system reflects is both the ways that corporations and corporate power rely on an inadequate system to force people back to work and force people to go back to work for low wages that cannot sustain their families. But it's also connected to a system of racial capitalism, right? According to data compiled by the Center for Popular Democracy, 47% of Black workers in America live in the 14 states with the lowest caps on unemployment benefits. By contrast, 7 states with the highest benefits have among the lowest Black populations in the country. And because of the United States' deep racial wealth gap, Black and brown workers have fewer, if any, resources to fall back on if they lose their jobs during a crisis. So I think, I think of this as closely connected to questions of anti-poverty, right? Because for many workers, this is the system that they will rely on if they lose their job, which they could. Most workers in this country also hold their jobs at will, right? They can be fired for any reason, a good reason, a bad reason, or no reason at all. And so if you know that your employer could fire you, for no reason at all tomorrow, and your average weekly benefit on unemployment insurance will be $252 in Alabama, that strikes me as a pretty significant problem for anti-poverty efforts. And lastly, I want to talk about another case study of extreme worker exploitation, the emerging problem of employer-driven debt. Today, many employers use debt to control workers, to undermine worker bargaining power, to trap workers in dead-end jobs, and obscure outrageously low wages. One of the worst examples of employer-driven debt are TRAPs, so-called training repayment agreement provisions. The term TRAPs refers to employment contracts and similar documents in which employers threaten to sue their workers to collect quote-unquote debt that those workers owe their employers if they leave before the end of a stated contractual commitment period. These agreements can take many forms, each worse than the next. So in an extreme example, the story on the screen here, many immigrant healthcare workers are trapped in bad jobs with staffing agencies who threaten to sue them for quote-unquote breach fees, quote-unquote liquidated damages, or lost profits from anywhere between, there's not an extra zero in this, $20,000 to $50,000 if they leave before the end of their contracts. Those fees are often many times a worker's monthly wages, and that threat either leaves people in deep debt if they need to leave a bad job, or that threat traps people more often in jobs with low pay, discriminatory bosses, or dangerous working conditions. So I'm leaving you with a couple of ways the law has allowed corporations to evade accountability, allowed employers to evade accountability for profound forms of worker exploitation that leave people in poverty, ways that the state has failed to alleviate poverty for workers in need. But the law also gives workers the tools to fight back. Those tools are too limited, they are too weak, they are begging for reform, and they are filled with loopholes, but they do exist. The wage theft, the disaster workers who I talked about first, who experienced tens of thousands of dollars in wage theft, were able to organize. They were able to educate their coworkers. They were able to hold their employer accountable. And today, they all work for a worker center that they have founded themselves, that is run as a worker co-op, that is educating other workers in the same space about how they hold corporations accountable, how they hold sketchy subcontractors and sketchy contractors accountable. Pandemic era fixes to unemployment insurance kept tens of millions of workers and families afloat during the pandemic, proving that we do not need a system of unemployment insurance that leaves the majority of unemployed workers out in the cold after they lose their jobs. And these nurses are bringing groundbreaking litigation arguing that these traps violate federal and state minimum wage laws, as well as arguably consumer protection laws. And perhaps most importantly, labor law is the law of how workers build and exercise real collective power. I will hold off on talking about the law of organizing because you're about to hear from many of its greatest luminaries on the next panel. And you're also about to hear, I'm sure, about its many limitations. But I want to leave you with one last piece of evidence that poverty really is a policy choice. Last year, hot labor summer, UAW workers at Ford won a 25% raise over 4 years, including a 11% raise immediately, reversing a decade of stagnant wages and making up for the fact that they took pay cuts during the 2008 crisis, during the auto crisis, to keep the business afloat. Unite Here raised the minimum wage for workers in New York and New Jersey airports from $10.45 an hour to $19 for a largely Black and brown service workforce. Delta pilots got a 34% raise through 2026 and an 18% raise immediately. You cannot argue with those numbers. And I look at this chart right up on the screen here and I think, this is how we create shared prosperity. This is how we end poverty in the wealthiest nation in the world. And this is the best time in my lifetime to join the movement because we are putting real wins on the board. And so for those of you who are students, please, I encourage you to join the movement and be part of this because I think that this is, one of the ways that the law gives me the most hope. Thank you for your time.
We have a few minutes for a few questions.
Hi, thanks so much for your presentation. I had a question about whether there's movement either within DOL or at the state level to do anything on the issue of not grueling hours, but kind of the opposite, workers who want more hours but are limited to under like 35 hours or whatever the limit is for benefits, and also don't know their scheduling in advance, so they can't have any consistency.
This is such a great question about one of the issues that makes me angriest. I should clarify first that I'm here in a personal capacity and my opinions don't necessarily represent that of my employers or the acting secretary. Our ethics office has been very insistent that I tell everyone that. But it's a really important question. So many workers, and in particular workers in feminized workforces, retail in particular, but also healthcare and others, are subject to extremely abusive scheduling practices. Workers who want full-time work are not able to, and people have all kinds of good reasons to want part-time work, but a lot of people who want, research estimates anywhere between 35 and 60% of workers who are working part-time want more hours and their employers will not give it to them. So that's bucket one in scheduling. Many of those workers are also given fewer benefits, fewer opportunities to advance in the workplace, and paid less. And that's probably the reason, right, that their employers are refusing to give them more hours. They are trying to prevent those workers from both from qualifying legally for certain protections, but also from having sort of like more attachments to, like, they're relying on high turnover workplaces to prevent worker organizing. And third, a lot of people have wildly unpredictable schedules. So in retail is like generally considered the worst offender, but there are parts of the country where 40% of retail workers don't know their schedule just 2 weeks in advance. And that makes it impossible to hold down a second job, which you might need because your employer refuses to give you 40 hours of work, or to go back to school, or to arrange for childcare. And many workers also simply can't get enough sleep because they have to close their Starbucks location one night, and then they have to open the Starbucks location at 6 a.m. the next day. So, it turns out that as it currently exists, federal law does have relatively little to say about this, but there are some very exciting legislative proposals that I would encourage everyone to check out. Senator Warren has a part-time workers bill of rights that addresses the question of the exploitation of part-time workers, guarantees them equal treatment in pay, scheduling, benefits, sort of opportunities to advance. And there's she also carries a Schedules That Work Act that addresses unfair and abusive scheduling. Many states and cities are considering similar legislation, and fair scheduling legislation has started to not just move, but pass in a number of cities over the last 5 years. So I think if there's going to be progress on this realistically in the next 5 years, it's probably going to be at a local level, but never say never. And it is certainly something that many unions, including UAW, have bargained over a lot. In fact, one of UAW's top priorities in its Big Three contract negotiations last fall were protections for part-time workers who are often paid, were subject to significantly lower compensation under the previously existing contract.
We have time for one more question.
Well, I take it everyone is convinced that labor and employment and anti-poverty law are concentric circle, but I'm happy to talk afterwards if anybody would like to.